Good morning. My name is Lisa Daisel. I'm from the Unisa Directorate for Career Counselling and Development. A very warm welcome to our Career Focus event this morning. We are very excited to have Advocate Happy Nkabinde with us, and he will be talking to us about understanding the process to the legal profession. With me, I've got my colleague, Mrs. Mandu Makanya. She will introduce the speaker to us, and we will then be able to hear more about his journey and also some tips on how you can prepare for the legal profession, different fields. Our program, as I said, Mrs. Makanya will do the introduction. We will then have the presentation from Advocate Nkabinde. There will also be a Q&A session. So as you are listening to the presentation, please take time to post some questions in the Q&A on Microsoft Teams, and we will then attend to those questions after the presentation. Thank you very much, Mrs. Makanya.
Thank you, Lisa, and good morning, ladies and gentlemen. It gives me pleasure this morning to introduce our speaker for the day, who is also our alumni at Unisa. His experience includes working in legal drafting and litigation, which involves medical negligence law, personal injury law, procurement law, tender review applications, energy law, delictual law, enrichment law, labor law, international law, local government law, general practice in civil matters, general practice in commercial matters, and general practice in litigation. His work experience includes working at Unisa over a period of 4 years, where he worked first as a research assistant in public constitutional and international law department, which was followed by a position as a lecturer at Unisa, again in the Department of Public Constitutional and International Law. And he was a candidate attorney for 1 year with Leku Pilsen Attorneys. Further, right now he is self-employed as an advocate, a position that he has held for 5 years, practicing with a position as practicing advocate of the High Court of South Africa. And amongst his judgments that are on his name, it's the judgment on Charewa versus Accident Fund, as well as Bongiwe versus Road Accident Fund. He is not only an advocate in the High Court of South Africa, but he is also active in publications, in scholarly work. And his works includes publishing in 2 journals, where he wrote 2 papers reforming the multilateral decisions and making mechanisms of the WTO. And he also wrote a paper titled "Let Nuclear Energy Boil the Kettle of the Indigenous People." And he also has done a number of courses with Law Society in 2012, a course in practical legal training, followed by International Professional Development course with King's College of London and the University of Witwatersrand in 2014. Also a course in International Professional Development with the title Nuclear Security Culture and Cybersecurity, which he did with King's College of London and University of Witwatersrand. He also did a course on International Professional Development on Nuclear Security Regulation with the same university and King's College London and University of Witwatersrand. And he also did the same with did the course in International Professional Development in Introduction to Nuclear Security with King's College of London and University of Gajah Mada in Indonesia. He also did an advanced nuclear security curriculum review workshop with King's College of London in Vienna, Austria. Also did a professional development course in nuclear material and accounting and forensics in 2015 with King's College, which I think he's actively involved with, which is a prestigious university in the UK, as well as Wits and the University of Massachusetts in the US. He also did an advanced professional development course in nuclear security training and education with the same University of King's College of London, University of Tennessee, and University of Witwatersrand. He did also a course in evictions and lease agreement with LEAD, which is the Legal Education and Development Law Society of South Africa. And lastly, he did a writing course for litigation with LEAD as well in 2019. And ladies and gentlemen, it gives me pleasure to welcome Advocate Happy Nkabinde to the podium, and we are so proud to be his alma mater. Thank you.
Good morning, ladies and gentlemen. My name is Advocate Happy Nkabinde. Those who know me just call me by Nkabs or just Nkabinde. I'll call you as colleagues or esteemed guests, but I prefer colleagues, seeing as most of you are in the legal profession or tend to be or want to be in the legal profession. So my presentation today is about the careers in the legal profession, how you go about it, what are the challenges, what are the obstacles, and what you should do as a Unisa student, considering that I'm a Unisa student myself, with the necessary background that would guide you along the way in your journey to become something within the law profession, whether being an attorney or an advocate or legal advisor or anything else involved in the legal space. So that is my job for today. Lisa, could you kindly assist me with the presentation? Yes. Colleagues, so mine is not going to be too long. In fact, I would encourage more questions so that we can cover all that you can think of that I may not have covered in the presentation. So what we're going to go through today, what I'm going to talk about is the education and training that you need to do that you get in the legal profession, in the legal space. And then we're going to talk about the different types of professions you get within the legal field. We're going to just briefly touch on the Legal Practice Act 28 of 2014. And then we're going to talk about the opportunities that are available for you within the legal spaces. So this is what we're going to be essentially touching on today. And I encourage you to ask as many questions as possible. Thank you. Lisa? Thank you. So with regards to the education and training, I can speak from my personal experience that when one comes to Unisa and studies for a law degree, we study an LLB. So the LLB is comprised of about 40 modules, and it's qualified as an honors degree. Therefore, it means immediately after doing it, you would then be able to qualify for doing your master's degree. So once you are done with your LLB degree, which should take you about 4 or 5 years, if you're a diligent student, 4 years, then you would either move to go to law school if you're interested in being a legal practitioner. Then you would go to law school. Law school is hosted or conducted by LEAD, which is under the Law Society of South Africa. We now call them the LPC, we call them the Legal Practice Council in terms of the new act that came in 2018. So law school is comprised of two groups. You have a day group and a night group. So the day group is for students who want to attend full time, and then the night group is those who would also want to attend but are currently employed as candidate attorneys, or they're employed somewhere else, so they can only go to law school at night. So law school lasts for a period of about 6 months. And during your period at law school, you have to write certain exams which prepare you for your practice as a legal practitioner and also for your board exams. That's if you want to be an attorney. So law school is primarily when you get out of university, you move to law school. That is if you want to be an attorney. But however, if you want to be an advocate, on the other hand, you complete your LLB and then you apply for pupillage as there is no law school. That is how it's done. And then moving from law school, depending on which stream or avenue you intend taking, you then do articles. Articles are done for a period of, as per the Act, 1 year to 2 years. But your articles are considered complete once you've completed a full year of uninterrupted serving. So you serve under a principal. So that principal is an admitted attorney with no minimum, no less than 3 years experience as a director or a person who's been in the profession for no less than 3 years. And then you serve as that person's candidate legal practitioner, and they expose you to the entire work of what they do as an attorney. You would be serving at their firm. And I can tell you, considering that I've done articles, it's not a glamorous job. There are many and very long working hours, and there's quite a lot of frustrations with it that come with it, but it's all worth it in the end. So if you don't want to become an attorney, legal practitioner, you can then move to the stream of becoming an advocate. So in order to become an advocate, you have to serve pupillage. And pupillage is now compulsory after the Act, the Legal Practice Act came into effect in 2018. So pupillage has now become a compulsory aspect. Before 2018, before the Legal Practice Act came into place, anyone would, upon completion of their LLB degree, make an application to the High Court to be admitted as an advocate, and they would be admitted in terms of the Admission of Advocates Act. However, the Legal Practice Act has demolished that direct route to becoming an advocate, and it now makes pupillage compulsory. So what is pupillage? Pupillage is similar to articles. So in pupillage, you then serve as a pupil under a mentor, or we don't like to call them masters, but we call them a mentor. So they do basically the same principles and take you through the same journey as a candidate attorney would take with an attorney. You would then take the same journey as with an advocate who is admitted in the profession. Pupillage is served for a year, for 1 full year. And upon completion of pupillage, then you'd have to then write what we call a bar exam. And if you then would want to be an attorney, you'd have to write what we call board exams. So after you've served articles or pupillage, you then move to the next stage of writing board exams or bar exams. Note that you will not be admitted into the profession unless you've completed these steps. You would have to pass your board exams, all 4 of your board exams, and you'd have to pass all 4 of your bar exams. So could you next slide, please, Lisa? Thank you. So I think I've explained what's happening here. It was just a recap to say, yes, the Unisa Law module comprises of the 40 modules. It's an honors, it's a 4-year honors module. 4-year honors, you then have to do 1 or 2 years of articles, 1 year of pupillage or 1 year of privilege, and then after that you'd then do your bar exams or your board exams. Next slide, please. Yes. So when one is then admitted as a legal practitioner, we no longer use the term lawyers as per the Act. The Act calls us now legal practitioners. We are no longer lawyers. So in terms of the Legal Practice Act, there are 2 forms of legal practitioners. There are either attorney legal practitioners or advocate legal practitioners. I was on the aspect that in terms of the Legal Practice Act 28 of 2014, we are no longer called lawyers in the colloquial sense of the term. We are now considered as legal practitioners. So what are the requirements for becoming a legal practitioner? So in order to be a legal practitioner, you have to comply with those requirements that we've stated above. That means you must have a law degree, you must have done your law school if you want to be an attorney legal practitioner, you must have done your board exams, and you must have served articles for a year. Or you must have a law degree, you must have done pupillage, and you must have passed the bar exams if you want to become admitted as an advocate. So what the Act then requires is that when you make your application to be admitted as a legal practitioner, either advocate or attorney, the Act, the judges who then listen to this application that you make have to ensure that you are what is considered a fit and proper person. Now, as to what is a fit and proper person can be argued all day, but the essence of the matter is, if you have judgments pending against you, if you have like a criminal record pending against you, or you have judgments pending against you, or your principal or your mentor, they don't write good reviews about you during the time in which you are serving pupillage or you are serving articles, that in itself then counts against you when the courts have to find whether you're a fit and proper person. Also note that this application you make to the High Court of South Africa. Although you make it to the High Court of South Africa, you would also have to give this application to the Legal Practice Council, the LPC. The LPC is the body that regulates all legal practitioners in the country. You would also have to serve them with this application to tell them of your intention to be admitted as a legal practitioner. Then they also have a right to object to you becoming a legal practitioner, or if they don't have an objection, they then state that in a letter saying that they have no objection to you becoming a legal practitioner. Also note that there is a mandatory application fee that you pay to the Legal Practice Council. You pay that fee as well, and you also show to the court that you've complied with all the requirements of becoming admitted as a legal practitioner. So the certificates of your degree certificate should be attached to the application that you make. If you've done articles, then your principal will then have to make a confirmatory affidavit to show what skills they have taught you and if you're competent and proficient in what you've been doing while you're working for them for that period of a year. There have been cases where people have not been admitted as legal practitioners, owing for a number of reasons, sometimes technical and sometimes material, serious material reasons. For case in point, quite a few people have been not admitted as legal practitioners because they had criminal records and those criminal records had not been expunged. And the court stated that those people are not considered fit and proper people, fit and proper persons to be admitted into the profession. Why the court requires this high standard of being a fit and proper person is because this profession is what we consider a very noble profession. So one has to have very high ethics and a very high standard of virtues. So considering that a lot of the public trust us with firstly their money and firstly their futures. So if I'm defending someone who is accused of murder or any other crime, that means that person trusts me with ensuring their freedom. If I'm defending an old lady from the squatter camps or an informal settlement because she's being evicted, that is her home. So that's why the court places a very high standard of ethical conduct for any person that comes into the profession. So that's why there's a very, very firm emphasis on fit and proper and being a proper person. I've seen a person who had stolen a chocolate while they were 13, and at the time that they wanted to be admitted, the person was 28 years old, and the court refused that this person be admitted as a legal practitioner. And if one does not have sound, how do I call this? Sound control of their finances. So if you've ever been blacklisted or you are under debt review and the likes, then the court also holds a very dim view towards admitting you into the legal profession. As you remember, you will be dealing with the public's funds, you'll be dealing with people's monies. So one needs proper financial management. If you can't manage your own finances, then the court is of the opinion, how would you then be able to manage the finances of the general public? Hence, many other legal practitioners get struck off the roll. If you're found that you steal clients' money or you eat clients' monies, you are then struck off the roll. That means you can no longer practice as a legal practitioner, or you are suspended for a certain period. It can range from 5 years to 10 years. So that's those are the strict requirements for becoming an attorney or an advocate. And if one decides not to follow that traditional route to becoming a legal practitioner, one can also go into academia. Like that's where some of us started. Some of us started in academia, and then we then branched out into practice. So that is also an option. And or you could do both at the same time. So quite a few people, lecturers or professors, and then on the other side, they are advocates or attorneys running their own successful law firms and running their own successful practices. So these are some of the other opportunities that are available for you with the law degree. So if you then set your sights on academia, you can either be a professor or a lecturer or a researcher, as some of us were. And then in order to do that, you would then need to upskill yourself and do another qualification, which is a postgraduate qualification, either being an LLM, a master's, or if you'd want to get to the highest level of them all, to becoming a professor, you then need to get your doctorate, which is an LLD. And apart from academia, there are instances where you do not want to become admitted as a legal practitioner, and where one thinks that, or one is of the view, or you feel that the profession to becoming a legal, the route to becoming a legal practitioner is long and strenuous, and or just practice in itself is not your forte. Then with an LLB degree, you can then get into the corporate space as well. Then you would then become a legal advisor. And a legal advisor has a wide ranging jobs. It's just very job specific. So could you go to the next slide, please, Lisa? So as a legal advisor, you could work for anyone, basically, in the corporate space. You could work for and do almost anything. But the fact of the matter is you wouldn't be practicing. So you wouldn't be going to court. You wouldn't be preparing legal documents per se. So therefore you would just be limited to office work and writing or drafting legal opinions and legal briefs, and advising on, let's say, legislation as to how it affects your clients and the likes. So law, as I was once told by a professor, that in law you can do anything from A to Z. So you can be a lawyer specializing in aeronautics to a lawyer in working in a zoo. So across the board from A to Z, you need a lawyer involved. There is always legislation. There is something that requires law in every field you can think of in the world. I mean, there's something that I recently learned called space law. So that is recently a new area of law that is going to be focused on when people start claiming space on Mars or on the moon. what governs those relations between those parties, and also in space itself. But anyway, that's a debate, conversation for another day. So briefly here on this on this page is some of the aspects of law that I'm involved in, that I've practiced in, or I've researched in, or I've written opinions in. But so this is the areas of law that I profess to know. So I do medical negligence law, personal injury law, procurement law. Basically, those are tender reviews. So if one party is aggrieved that they didn't get a tender, we do PAJA and PAYA applications, and then take those applications to court, compel the state to produce evidence so that we can review the application at the tender process itself. So energy law, I've done a lot in energy law, especially in nuclear energy law. I've done quite a few courses in nuclear energy regulation. As the introduction was saying, that I've done quite a few courses with King's College in London, with WITS and University of Gajah Mada. So energy law is one of my fortes. And then you have law of delict, delictual law. So that would be basically if you are suing for a delict that has happened against you. So let's say you get involved in an accident, you need to sue the RAF. That is delict basically, because you've lost something. You would have lost income, you would have been in pain. So that is the law of delict. So I also deal in enrichment law. So basically undue enrichment. That's just primarily civil litigation. Labor law, whether for the employer or for the employee, we dabble in that as well. International law. So international law is also tied a bit to the energy law that I was doing, but international law, it would be in the realm of international economic law, wherein we look at the legislation and the practices of the WTO. So we maybe draft an opinion if, and maybe an organ of state needs an opinion on, let's say it wants to implement something. Let's say they want to implement export taxes. So then we would then have to then draft a legal brief or legal opinion on the implications of export taxes in terms of international law and how that would affect South Africa in its international standing. A very big and topical issue right now in international law that affects South Africa directly is the ICC and the arrest warrant of the Russian President Vladimir Putin, and whether they should arrest him or they shouldn't arrest him, and whether Diplomatic Immunities Act applies to the Rome Statute, which have both been domesticated into South African law. So those are the issues that one is confronted with in international law. Local government law deals with basically municipal regulations, bylaws, those kind of aspects. Those are the aspects that we also deal with. And then basically general practice in civil matters. If you want to evict someone, if you are drafting a contract between a bank, or a bank wants to repossess its vehicle, all of those things fall under general practice in civil litigation or commercial. So these are some of the aspects that I've had the opportunity of working in and being involved in. So it's not impossible, it's doable. I mean, I started at Unisa and I've gone through the entire process, and I can safely say I'm proficient in any of these fields of law, and I can do just as good a job as anyone from any university anywhere in the world. Could I have the next slide, please? So one thing I needed to talk about is that with the coming into play of, or the enactment, or after the signing of the Legal Practice Act, what the act was, the act that we spoke about up there with regards to the admission of attorneys or advocates. So government also then set out to say, but the legal profession is very expensive, because you essentially, as a client, pay two people. So you are paying the attorney firstly, and then you're also paying the advocate, you see, because they split their duties. The attorney does the admin work of it and then gives the job to the advocate to then go and litigate or present your case in court. So then the purpose, but then we need to reduce costs. So one of the new things that the Act came in with was that they created a new form of advocate, or a new breed of advocate, called the trust fund advocate. And I put it trust fund in air quotes because these advocates work primarily like attorneys, and let me explain the difference. So the traditional or common attorney advocate that is known out there is what we call a referral advocate. Like myself, I'm a referral advocate. So basically what we do is that we take briefs from attorneys. So as a client, any Joe, Jack, and Jill on the street. So those clients, those members of the public would then give, let's say, a case to an attorney to say, I need to sue A, B, and C, for instance. And once they then give that case to the attorney does all the, we call it admin work, but it's also legal work because it involves drafting of pleadings, exchanging of notices. It's just legal documents, but it's more of an administrative task. Then once that is done, they then give all of that to the advocate to then prepare their case in court. So then the advocate would then do the research behind the matter and then maybe draft an opinion on what would be the best way of arguing the case in order to win it. And then from there on, then the advocate would then take it to court. So these advocates, referral advocates, they either belong to a bar or they can be independent. So a bar is just basically a grouping of advocates. So they share chambers, they share, let's say, a building, and each of them have an office in that building. Let's say Sandton Chambers or Groenkloof Chambers, Brooklyn Chambers. There's plenty of chambers. Mainland Main Chambers, there's quite a lot of chambers, and there's a number of groups basically that create these chambers, these bars. So it's basically, it's like a boys club or a country club just for advocates. So they belong to a bar, or they choose to be independent and work on their own and not share chambers in order not to pay bar fees or any association fees. And so once they get the brief from the attorney, they then work on the case, and then they are the ones that go to court and litigate in this aspect. Now, these referral advocates are not supposed to have direct access to clients, meaning the public. So therefore, they can't solicit work or get work directly from members of the public. These advocates' clients are the attorneys themselves. So it would be the advocate, the attorney, and then the client. So the go-to between the client and the advocate would be the attorney. So that's what we call a referral advocate. Now, this leads to a duplication of fees because when you go to court, the advocate charges his day fee, his appearance fee, and if the attorney is there, who they are supposed to be there on the day of court, they also charge the appearance fee as well. So you find the client paying for the attorney and the advocate for one day, for both of them being at court. So this seemed a bit unfair. So then legislation came into place and then said, no, let's create a trust fund advocate. So these advocates can have direct access to the clients. But in order for them to have direct access to the public, they need to comply with additional requirements that are set by the Legal Practice Act. So basically, on top of getting your LLB degree, doing your pupillage and passing your bar exams, one would also need to pass a module that attorneys do called bookkeeping and another module called practice management. So these are the other courses that the attorneys do, that if one wants to be admitted as a trust fund advocate, you'd also need to do in addition with what you were required to do as per the Legal Practice Act. And once you've done all of this, you are then able to have what we call a trust account. All attorneys who practice for their own gain have trust accounts. So trust accounts is trust monies, meaning money is held in trusts, meaning this money does not belong to you as the legal practitioner, but belongs to the client, therefore trust. Yes. So then one would then need to open a trust account as an advocate of the High Court. This is done to save costs of having to pay double. This is done to say, nope, you've cut out the middleman, you've cut out the attorney, and so the client can then approach the advocate directly if this advocate has a trust account. So basically, these advocates perform the duties and functions that an attorney would ordinarily do. But on top of that, they can also be able to go to court and present their own cases. And one thing I omitted to mention is that even attorneys can go to court and present their own cases. That's also fine. They don't need to brief advocates all the time. So, yes. Can I please have the next slide? So, attorneys, there's a saying amongst attorneys, it's very elitist in, I say it's elitist because notaries and conveyancers say all notaries, all conveyancers are attorneys, but not all notaries, not all attorneys are notaries and conveyancers. I'll come to this point just to explain it further. So basically, if you then chose to become an attorney, so basically you would have done your LLB degree, you've done your law school, you've passed your board exams, you've done your articles, and you've been admitted. Court has said you're a fit and proper person, you've complied with all the requirements, you're an admitted attorney. On top of that, if you want to then specialize, there are other forms of attorneys. There's quite more others, but the main ones, the big ones, are notaries and conveyancers. So notaries public, we call, with, for instance, notarizing a prenuptial agreement. So if me and my partner decide to marry and I want to have an antenuptial agreement, would need to go to a notary public for them to notarize that agreement. And even other agreements need some other agreements that are maybe technical, or they involve big stakeholders like countries, like diplomats. They are also notarized. And so then on top of that, you then have attorneys that become conveyancers. And then conveyancers deal with the transfers and sale of properties. They just specifically deal with that. So notaries and conveyancers are attorneys, but not all attorneys are notaries and conveyancers, because in order to become a notary or a conveyancer, you then need to do additional courses and pass those exams. You need to pass the notary's exam, and you'd also, if you want to be a conveyancer, you'd need to pass the conveyancing exam, which I've been told is not the easiest exam to pass, especially the conveyancing exam. Last I checked, a friend of mine who's a conveyancer told me that the pass rate was 18%. Not that I'm discouraging you or anyone, but it's worth going into, it's worth looking into. I think the more people in the litigation space, the better. And then apart from being a notary or conveyancer, you can just become a litigator. So basically, the fields of law that we were speaking about. So you would then, if you're a litigator, you would work for a specific law firm, or you would work or have your own law firm. So if you have your own law firm, you can do whatever field of law you want. Some people specialize in, let's say, deceased estates. Some people then just specialize in family law, and others in just criminal law. So that's if you want to work for someone or you want to work for yourself, and you just choose to specialize in that field. And so basically you just become a general practitioner of the law. Just like doctors, you have general practitioners and then you have specialties. So those doctors that specialize are like these attorneys that specialize to become notaries, conveyancers, and the likes. And if litigation and practice is not your forte, then you can then move on to become an advisor in any corporate space or in any government space or any other space. For example, even in law firms, you then can become an advisor as an attorney. So there are people who are admitted attorneys who've complied with all of those requirements, but they just prefer to become legal advisors. Can we have the next slide, please? So as an attorney or as an advocate or as an advisor or as a notary or a conveyancer, your workspace options are far broad, very, very, very broad. And as I've stated before, one can work in, let's say, an aeronautical engineering company as an A and end up working in a zoo, Z. So A to Z is covered in the legal space. So mostly go into banking and insurance. Those are primarily the legal advisors and a lot of attorneys go into banking and insurance. And then some go into state-owned entities, maybe your Transnet, your ESCOMs, or government departments. So your state-owned entities, you get quite a lot of advocates practicing there as well. And then your government departments, depending which government department, you then get the advocates or attorneys. Like the largest law firm, if I may call it, for the state is the state attorney, and they is just filled with attorneys and very, very few advocates, because the state attorney themselves function as a law firm. Then they are able to brief advocates who are independent or are affiliated with the bar. As an attorney or as an advocate, you can also work in the legal aid board. I must say that when we look at footprint-wise across the country and look at workload, the legal aid board can be classified as the largest law firm in the country, although it is what we call a parastatal, like sort of an SOE. It's not government, but it gets funding from government in order to bring legal services to the public. Hence, its services are for free. So we can call it the largest law firm in the country in terms of footprint and workload. And it's mostly attorneys that work there, and also a few advocates there and then in between. And then you can either work in law clinics. Law clinics as well are populated by attorneys and yes, attorneys. So basically in a law clinic, you can also serve your articles or anything. Law clinics, if I may explain what a law clinic is that universities that offer law as a main course curriculum, like Unisa offers the LLB law degree, like University of Pretoria or any other university that offers law. They have what we call law clinics. So law clinic functions as a law firm, but within that university's law faculty. And what they do is that they offer legal services to people who pass their means test. So basically, people who are too rich for the legal aid board, but they're too poor to afford a private law firm. So these are the people who are caught in the middle between failing to say, if I say I earn 10,000 Rand a month, I may not be able to pass the means test for the legal aid board, because the legal aid board would say, no, but you earn money, you earn more than 6,000 Rand. But that 10,000 Rand is not enough for me to afford a private law firm or a private attorney. So I'm stuck in the middle. So this is where law clinics come in. Law clinics then bridge that gap between the legal aid board and private law firms. And then, yes, so they also offer basic services like assisting in divorces, labor law matters, evictions. They don't do like civil litigation wherein you would be getting money let's say from the RAF, where you are suing, let's say, the state. They don't do such matters, but they do other civil litigation. It's primarily for the good, wherein one doesn't stand to make a profit. That's where that's the space they work in. And then you can choose to work in a law firm, a private law firm. There's many law firms out there. So you get the general big five law firms that are found throughout South Africa. We call them the big five. So you get your ENS, those firms, your Bowman Gilfillans, those are considered the big fives. I just forgot from the top of my head which others are considered the big five. But those are the big five law firms. It's like the big five banks. And then you have millions of or thousands of other small law firms that are owned by many other legal practitioners, either in partnership with other legal practitioners or independently. So instead of working for someone else, I would be opening a firm called Nkabinde Attorneys Incorporated, and I run my law firm from my house. So there's quite a lot of law firms that are available for you to work at out there. And then if you don't choose to follow these with a law degree, then you can then work as in the academic space. Also employed as an attorney or an advocate. So usually universities also have what we call legal departments, which are different from the law faculty. So these legal departments handle what we call memorandum of agreements. They handle the labor disputes of the employees in the universities and the likes. So they don't operate as a law firm, but they handle the legal complexities that the university will be faced with. Next slide. Yes. I don't know if there are any questions. Any questions from the floor? Just
can I read them out for you, and then you could just respond to them?
Yes.
Okay, so Noluthando is asking, how do I become a legal advisor at a company?
Okay.
Now, I guess I was listening to your presentation. Something I've always wondered about. There are, in terms of law, you've got the LLB degree, but then you've also got students who complete, for example, a BCom law. So somebody with a BCom law, for example, would they need to also complete an LLB, for example, to go and work as a legal advisor then? So just a bit about, the legal advice field.
All right. Thank you. So basically, in order for one to become a legal advisor, you don't primarily need the LLB degree, but it depends on the scope or the field you intend to go in. So in BCom law, and I'm subject to correction, the primary focus is on the corporate aspects and the economic aspect of advising. So in the BCom law modules, you would be exposed to modules such as economics, which you would not find in the law degree. You'd be more exposed to modules of finance that you won't necessarily be exposed to with the LLB. So BCom law degree is by all means one of the best ways to become a legal advisor. You end up working for the banks, you end up working for the insurance companies, you basically end up in the corporate space. And if you want to be a legal advisor with a LLB degree, similarly as well, you would just need the LLB degree and that's it. And you can qualify to become a legal advisor. It just depends on the company that is looking for the legal advisor, because some companies would say, we want a legal advisor who has experience in litigation or in practice. So if they're looking for someone like that with that kind of skill, then that person would have had then to be admitted as a legal practitioner. But you can actually become a legal advisor with just a BCom law degree or just your LLB degree without having gone to law school and being admitted as an attorney or an advocate. I know quite a few legal advisors, and one is head of legal at Outsurance, and he's just got the LLB degree. And so I know another legal advisor with just a BCom degree. He's just a legal advisor also at Outsurance, funny enough. So you can be a legal advisor, no problem, no hassles. It just depends on what are the requirements of that particular company that's looking for them. I don't know if there's any other questions.
There are still a few. Okay, you did mention about the criminal record, but there was a question about, can one practice as an attorney if one has a criminal record? So I'm not sure if there's anything else you would want to add.
Okay, criminal records, it depends as well. What type of criminal record? So if I was, let's say, an apartheid struggle stalwart, and I have a criminal record because I was opposing apartheid or I was fighting apartheid, there's a case I'm dealing with right now wherein someone needs to be admitted as an advocate, but they have a criminal record from apartheid times. That won't pose a problem because it doesn't speak to a malicious character that this person poses, but that criminal record was the result of an unjust system. So the criminal record, also you take it with a pinch of salt. So if I, let's say for example, 20 years ago, assaulted someone and I had a criminal record, and it can be seen that I've reformed, then, and if the court is convinced that I have reformed, in fact, now I'm involved in NGOs that advocate against violence and gender-based violence and the likes, then the court will then say, okay, no, it does show that, you know what, I've made amends, I've changed, I'm a new person, and then I can be admitted with that criminal record. But in your papers, to be admitted as an attorney or as an advocate with a criminal record, you must show to the court, like you must demonstrate that, firstly, this thing happened many years ago, and you've paid the price, you've made amends, and you then implore the court to then admit you with that criminal record. But if you have a criminal record for theft of monies, let's say I work at a bank and I embezzle funds from the bank, I go to jail. While in prison, I then complete my law degree and I want to be admitted as an attorney with this kind of criminal record. It's going to be very difficult for the court to actually admit me as a legal practitioner or as an attorney, considering the type of criminal offense that I did. Because it involved embezzling money. And therefore, if I was convicted of such, what is to say that I wouldn't do it again when persons trust their money with me? So it's that kind of situation. So it also just depends on type of criminal record that you get, and it speaks to the character. That's why they say, are you a fit and proper person? That fit and proper person aspects speaks to the character of the individual. Thank you.
Thank you so much. There's also somebody who asked, what is your experience as an Unisa student? Do you find that the Unisa qualification is also well recognized?
That's a very good question. I was actually hoping that someone would ask this question. You see, there's a misconception out there that, you know, students who got their degrees at Unisa or their law degrees at Unisa, they don't know much, you know, and they are substandard of some sort. I can tell you with 100% conviction and confidence that that is the furthest thing from the truth. My experience is that I started with articles. Immediately I left Unisa, I went and did articles. And I can tell you the law firm I worked in had about 4 Unisa students working there, and about 3 students working from other universities. The 4 Unisa students excelled more than those who had gone to other universities. I'm not going to say their names. I'm not defaming them or anything, hence I won't say their names. And one thing I found that Unisa students have an advantage over the residential going university students is that we have the ability to work independently. And that gives us an edge, even with employers, to say we don't need to be spoon-fed and nannied all along the way in doing our work and producing work on time without being followed now and then, which then works to the advantage of the Unisa student. That's in the professional law firm setting. And then I wanted to become an advocate, and then I became an advocate after doing articles, and yes, I got admitted as an advocate. Long story. In my profession and my experience as an advocate, one thing I can tell you is you are as good as your case is. That's the first thing. Regardless of which university you went to, you could have gone to Harvard and Oxford in America and the UK, and I could have come to been a Unisa student. I'm as good as my case is. And I can tell you with no fear, no favor, I've wiped the floor with university students or counsel who've been to other universities. In fact, even senior counsel than me, people who've been in the profession longer than me. And that time I've been a Unisa student. So this aspect that, oh, you're going to lose if you are represented by a Unisa student, it's not the case. I mean, one thing we should be proud of is that, you know, there are senior counsels out there and who come from this very institution, you know, and that is not recognized. So what I can say is, whatever they say, whatever the naysayers say out there, it's you as a Unisa student, you need to hold firm and make sure that your work ethic speaks for you. And when that work ethic speaks for you, then slowly but surely we then disseminate and remove all these stereotypes about what they say about our beloved university. Is there another question?
Yes, related to that is what can I do as a student to help me prepare better to become a legal practitioner?
Okay. My experience as a Unisa student is that one, you need to be involved and you need to be proactive. So it's all good and well that you can sit behind your computer and submit your assignments and read your books and write your exams over the computer and never leaving the comfort of your home. However, it does not prepare you. You're only prepared in the theoretical aspect of it. When it comes to the practical aspects of it, it's a totally different paradigm shift. It's a complete mind change. And I would suggest that in order for you to prepare yourself for that, is that be involved in other things, like going for experiential learning. One thing I did through this department that's hosting this is that I got involved with working with the Legal Aid Board. So once or twice a week, I would be working at the Legal Aid Board for free. And that better prepared me and better equipped me to become better than my peers when we were all admitted, because I had the exposure to the kind of work that was being done in law firms, you know. And also, one other thing I've noticed that helps a lot is just going to court. You just go to court, you sit. Court is an open court unless it's in camera. You sit in court, in an open court, and you listen to the flow of arguments. That in itself just reshapes your mind as to how you think of legal arguments, even that you've read about in theory, but then you're able to reshape your mind to say, oh, now it connects. What I read in theory, it now connects with what this person was saying. And now I understand why it was put this way. So just even going to court really does help. And it better prepares you so that when you are in that space, you're not left juggled and shocked by what's happening in the practice space.
Thank you. There was also somebody who asked about how do you go about finding articles or pupillage opportunities?
Okay. So with articles, what you can do is on online, you can just go online and search for articles. Usually law firms are advertising as well online, or there's notice boards outside the magistrate's court and the high court, or I mean inside the magistrate's court and the high court, wherein law firms put up vacancies for, let's say, candidate attorneys or even admitted attorneys. And I think you guys are more lucky because you live in the day of social media. You know, most of these other article vacancies are published on social media. I've seen articles, vacancies for articles being published on Facebook, and some of them being circulated via WhatsApp. So that is one way of getting articles. Another way is literally just walking into a few specific law firms that you may want to work at and dropping your CV. But when you do that as well, you must have an edge, so above someone who also has the same qualification as you. So you, at least if you say, I've done experiential learning, or I participated in a moot court, I did a street law program, I know how to present, I did a debate program, those kind of things, they also assist. So those are the ways in which you can go about getting articles. And with pupillage, you apply for pupillage through any of the respective bars. That's if you'd want to then belong to a certain bar. So let's say you are from Joburg and you want to belong to the Masons group or the PG Chambers or whichever chamber in Joburg or in Pretoria, the Brooklyn group, Circle Chambers, whichever one. Then you'd go onto their website. Let's say, go to Tshwane Society of Advocates or Pretoria Society of Advocates or Johannesburg Society of Advocates. These particular three are very good sites. Tshwane Society of Advocates, Pretoria Society of Advocates, so on these three websites or three sites that I've mentioned for the Pretoria, Tshwane, and Johannesburg bars, then you can then get into the links and then fill out application forms to belong to, so that with their next intake that they can consider you. Oh, one last one that I'd forgotten is Pabasa. You can just also go to Pabasa, so that's Pabasa, and then also apply to do pupillage with Pabasa as well. And so yes, it's those big four. They are very good sites for if you want to secure pupillage for the following year. But if you don't want to belong to those respective bars and you would want to maybe be an independent advocate, you can then, but you'd also need to do pupillage, but then you can approach any other advocate that's practicing independently and approach them, ask them to be your mentor. And then if they agree, then they take you through the pupillage program themselves as their mentor, as their mentee. My apologies for that. Are there any other questions?
Thank you. Linked to that, there is a student who said they're in their third year. I'm applying for articles and have applied for winter programs with no luck so far. I have done an online VAC work program as well. What more can I be doing?
Okay, I think that's a very difficult question to answer, and I'll do my best, because I think it also talks to the socioeconomic climate that we find ourselves in. I know that law firms are not too willing to take on new candidate attorneys because of the economic space that they're in right now. So it's quite hard for them just to take in maybe people who want to do articles, because the economy is not too good. However, in addition to what you can do to the above mentioned that you've stated, there is funding from SASETA. So basically it funds, so basically you get a stipend from the SASETA so that your articles are paid for. So I think they give around 3,000 Rand. You get funding for 3,000 Rand. Then what you could do is apply for that funding and get it. And it's not hard. Quite a lot of people get it. It's not a difficult thing. There are not many bureaucratic loopholes in getting that funding. And once you get that funding, when you apply for articles, then you can then be able to inform that law firm or that prospective employer that, look, in fact, I have funding. You can match it. So basically then it becomes 6,000 Rand, or you just tell them that, no, you don't even need to pay me. I'm just here for the experience. I have funding. I can work for free. So I've seen quite a few candidate practitioners do that, to say that, no, I have my funding. You don't need to pay me. Just give me the experience. That's all. And then that's what they do. And then some employers, then they say from the goodness of their heart, say, no, it's fine. as long as you have the funding, that means you're not going to cost me 6,000 Rand or 10,000 Rand. You're going to cost me, let's say, 3,000 Rand or 4,000 Rand, and then they just match that or just add maybe 3,000 Rand or 4,000 Rand on top of what you're getting in order for you to live and survive. So I'd advise that you look for the funding, yes, so that at least it shows that you're also proactive and that you actually just don't want their money. You actually just want that exposure, that learning, so that it gives you an edge above the other candidates. Thank you.
Thank you. A last question just about the articles there. Kumalo was asking, is it possible to do articles while on sabbatical leave?
Kumalo, it's going to be very difficult because the requirements in terms of the Act is that, firstly, you must do your articles for a period of time wherein you are solely concerned with or focused on those articles. So I've seen it being done with pupillage. So people would go on sabbatical leave and then do pupillage. I haven't seen it with articles though. So that would be a different aspect. For instance, if you own a company or run a company, you'd need to state that you were not running a company for that year when you were doing articles. So common sense just dictates that they would maybe apply the same standard to say, were you focused on anything else apart from your articles when you were doing your articles? So one would need to look further into it and look deeper into it. But I know that a few professors have done pupillage. They took sabbatical and then went and did pupillage. I don't think that with pupillage it's that difficult, but with articles I haven't seen it. So I would be remiss if I were to say yes, you can, or no, you can't, because I've not seen anyone actually do that, take sabbatical leave and do articles. Thank you.
Thank you. Advocate, I just want to check in with you. We said the event will be over at 12:30. That's what we negotiated also with you.
Yeah.
But we've got about 10 questions left. So I just want to check with you to be available.
Yes, I can go further.
Okay, thank you very much.
It's just got a reminder that says the meeting will go in 5 minutes though.
Yes, yeah, so it will still continue, but I was just checking if you are still comfortable to continue.
Still comfortable. I'm okay.
Also to do with the articles, a student asked, does one need to do both articles and law school?
In terms of the Act now, you need to do both. You need to do both. Previously, correction to that. You can do, when doing law school, you cut your articles from basically 2 years to 1 year. And if you don't do law school, then your articles are 2 years. You see, but then you still need to pass the board exams. So you can be admitted without law school, but you then need to do for 2 years, and then you would need to show that you're competent in the entire spectrum. So in most cases, just to be on the safe side, everyone just does law school and law school with the articles, just so that you have the wider knowledge. So basically, the theoretical part that you're getting from law school is then being able to put to use in practice when you're doing your articles.
Yeah. Masahlaba shared with us, and I think it's quite relevant for a number of Unisa students who especially, they've already got established careers, but now they are studying law and they need to go through the process. So she has completed the law school with University of Pretoria, and but the challenge that she has at the moment is she's got a full-time job in a government department, and being the sole breadwinner, to go and do the articles of clerkship, would be quite hard. So she's asking, is there any other way that she could do articles, for example, on a part-time basis without quitting her job? So are there any options available for somebody who is full-time employed is the basic question.
Unfortunately, I don't think you can do articles part-time because it requires you to be full-time and learn fully what you're being taught. However, in government departments, and I have a colleague in the city of Tshwane who completed her LLB degree, and another colleague in DTI who completed her LLB degree while they're working there full-time. So what they have within government is what you can get, what you call like a lateral transfer. So you can move from one department, let's say you're in a social work department, and move to, let's say, state attorney, and then serve articles under state attorney. It's a lateral department. You're still employed by the state, so you don't quit your job, but you are able to serve articles while you're still there with the state. So you'd still have your employee number, and you'd be doing the duties that those of a candidate attorney. So that is one aspect to look into, these lateral transfers between the departments if you are employed by the state on a full-time basis.
Thank you. Pumsa was asking, how have you seen technology changing the legal field over the past few years?
Yeah, Pumsa, that's a good question, and very, very relevant, because one thing I can tell you is that 20 years ago, if you couldn't type or use a computer, you were fine. But now, if you can't type or use a computer, you're a fossil. And one thing I can tell you is that in the next 5-10 years, if you are not able to move with the ever-changing applications that come with the legal space themselves, you're gonna be left behind. Case in point, right now, courts are operating on a paperless system. So in order to create a case and even appear, so you could have an entire bundle like of 300 pages and it's online. So there would be no physical document of it. And so those things, applications and sites like that are operated by the court, by the judiciary themselves, such as Case Lines and Court Online. And we are seeing that people who don't embrace technology are then left behind. They are not able to use these technologies properly, and not embracing the technology, it means that you're not efficient like everyone else. So you would find that your case gets removed or dismissed because you failed to upload documents, or you failed to do certain procedures online, which are just standard you could have done if it was paper format. But those who don't embrace then the technology then are left behind. I mean, secondly, technology is working very well in regards to also case management of law firms. And I've seen that. I've also done that with myself, with my practice. I employ technologies for, let's say, debt collection. So I then have updates with regards to which attorneys owe me and for how long they've been owing me, and I get updates and notifications. So similar programs and then applied to case management and file management. So when a file comes in, it's put in the system, and when, let's say, prescription comes up, a month before or 2 weeks before prescription of the file, you get a notification. When a file moves from one hand to another, that movement is tracked online as well. So there's a number of ways in which technology is assisting. You also have programs like Ghost Practice, wherein your billable hours are recorded immediately as you work. So we've been online now for an hour and a half. So basically, my billable hours for the hour and a half that I've been working here, or let's say I have been typing, would then be automatically recorded against the file so that I don't lose any billable hours. The documents are available online, and I mean, within that software, and so that everything is done more expediently and faster as possible, as fast as possible. So in technology is not slowly but surely, but very fast, playing a very big role in transforming the legal profession and changing the legal profession. So we need to adapt, or we're gonna be left in the past.
Thank you. Kirsty is asking, or she's saying that she will be completing a diploma in law this year and would then want to venture into family law. So what would the next steps be?
So Kirsty has done the diploma in law and wants to do family law.
Yes.
Okay. Kirsty, with a diploma in law, you won't necessarily be able to become a practitioner, but with the diploma, you would be able to become an advisor or a legal consultant. So with a diploma, you can open what they call a legal consultancy. It's not a law firm, so it doesn't meet those strict requirements of a law firm, but it's a consultancy or an advisory firm. And if you want to do those, that's also fine. However, in that family law aspect, you wouldn't be able to appear in court with the diploma. You won't be able to, let's say, issue summons or draft notices that pertain to divorces or estates or deceased estates or trusts and the likes. But you would be able to function in an advisory capacity and or a consulting capacity in family law. So therefore, a client would be able to come in and say, I want to get divorced. And then you'd then be able to give them the best options as to how to get divorced, which court they should go to get divorced, and even maybe if you are linked to or associated with other law firms, and then refer them to those law firms. Yeah, so that would be to the limitation that the law diploma gives you.
Thank you. There's also a question, what is the biggest mistake students make, which is making them struggle to find employment or even being successful in the legal field?
Personally, I've noticed that and I think I can also speak for myself, is that the one mistake I did was at one point I was nonchalant about my future. So when I say nonchalant, I mean I had an attitude towards thinking that it will be given to me, as opposed to me having to go out there and get it. So it's not a I don't care attitude. It's a, oh no, once I complete this, I'll get this, But unfortunately, the world doesn't work that way. And so you need to actually go out and grab things unfortunately, you just need to go out and grab it. No one's going to give it to you, especially not in this legal profession. And the other thing is networking. Students don't network, and networking doesn't require much. If you go to, let's say, here in Pretoria, in the magistrates court, there is a cafeteria there. If you sit and relax and have a conversation with an attorney at the magistrates court, network with them. They will connect you to someone else. If you are here in the Pretoria High Court, there are 2 coffee shops within walking distance. I kid you not, it's not even 500 meters to those coffee shops. They are flooded with advocates and attorneys in the morning and during lunchtime. If you would just be able to sit in there, have a conversation with one of them or 2 of them, and network. The more they see you, the better your chances. And the more they know what you have to offer, then the better your chances. And also, even if you're just at court, if you're at court and you get to just know one of the 2 of the court staff, they deal with these law firms directly, firsthand. And, I'm not saying that these law firms suck up to these court staff, people who work at court, but they're always there and trying to impress these court staff so that maybe the matter won't be struck off or removed. But if you know them and you say, no, if anyone is looking for a candidate attorney, maybe they can assist me. Believe me, these people are normal like all of us, and they also would want someone else to succeed. And if there is a vacancy, they'll ask, hey, is there like a vacancy for a candidate attorney at your law firm? They will make sure that a vacancy is open if they need favors from the court staff. So it's those things. But what I'm saying is networking really does help. Networking and not being nonchalant about your future, and actually having the guts to actually go out and take the initiative and just grab those opportunities that are out there.
Thank you. There's 2 questions also about the LLM degree. So somebody was asking, is it a good idea to do an LLM degree? What might the benefits be? And then there's also a follow-up question, can I still do my articles after completing my LLM or my LLD?
Yes. I would strongly advise that you do your LLM. Don't be like me, someone who's tried to do their LLM, but then now I can't finish my LLM because I'm too busy. If I could turn back time and actually finish my LLM and go back and say I'm focusing, I would greatly do it. LLM it's a good idea. Look, it's a speciality, in something, in a specific field of law, the practical applications to what you would be doing on a daily basis may not be there. So let's say I did an LLM in international trade law, but I work in a law firm that just specializes or just does labor law. That's fine. But remember, if I do an LLM and let's say I'm working for government or a state-owned entity, then that LLM just automatically puts me on a different pay scale. It puts me in a different tax bracket altogether. You know, if last I checked, I think an LLM as opposed to an LLB degree, an LLM puts you between 20 and 50K above the LLB. So it's not a bad idea. It's always a good idea to do it. And you can always do your articles after you've done your postgraduate qualifications, whether it being an LLM or an LLD. You can still do it. It's not a requirement that you must only do it while you have an LLB. No. I know a former professor of Unisa who is actually now an admitted attorney, but he had an LLD and then went back to did articles when he left Unisa, and he's now an admitted attorney. So it's never too late, and I encourage everyone to further their studies. It's never a loss. No experience is a lost experience.
Thank you. Samantha is asking you, how did it feel to go to court and present a case for the first time, and how did you prepare?
Yeah, it was nerve-wracking. The first time, it was really, really nerve-wracking. I literally didn't sleep. I prepared all night. I think I over-prepared at one point. It was so nerve-wracking after I'd received my first brief, and only to be disappointed that my case didn't proceed. The other side came with an offer that was too good to refuse, and we had to accept the offer. And all my preparation was in vain. Nonetheless, I've had many other cases, more than 200 other cases in different fields, and I can tell you that preparation prevents poor performance. The more prepared you are, the better you perform, and the more confident you get when you step into that courtroom. And for some of us, it's a dream come true. For some of us who've just wanted to be lawyers our whole lives, there's no greater feeling than presenting a case to the best of your ability and knowing that you're getting some innocent person out of trouble that they don't deserve to be there, or you're actually winning an often a certain amount of money that's going to help them for the rest of their lives. So apart from the preparation and walking in, I think the outcome, if it's in your favor, it's very rewarding. It's very satisfying. It's better than dopamine. It's better than sitting on TikTok the whole day and flooding your mind with dopamine. It's amazing. On the converse is that if you're also as invested as I would say I was in certain cases, and the case does not go your way, you almost get depressed to a certain point because you're so invested. It's as if it's you who's actually lost it is actually you who's lost the case, but the fact that the ruling is not in your favor and you are so invested, it's depressing. You don't want to talk to people for the remainder of the week. You just want to be alone and gather your bearings, and then so you can focus on the next one. So, but it's exhilarating. Being court is exhilarating. I wouldn't do anything else.
Thank you for sharing that with us. There was also a question, which one do you recommend between being part of the bar or independently as a referral advocate then?
It just depends. To be honest with you, it just depends on your plan and your career projection. If I can, I know many advocates who started off as independent advocates and then ended up going to the bar. And I know many other advocates who started in the bar and ended up independent, like resigning from the bar and working independently. So it just depends on your career aspirations and also what you get from being in the bar as opposed to what you get from being independent. I mean, if you can see that the bar no longer serves you and you're paying 20,000 Rand a month in bar fees and, you know, and you're able to get the job apart from being assigned to or associated with the bar, you're able to do the job with the attorneys that you have, the clientele and network that you have with those attorneys, even when you're not at the bar, then it's 20 grand you can save. But if the bar serves a purpose for you, to say that if it's not for the bar, you wouldn't have the connections and the linkages, then the bar serves a purpose. Then it's always good to be associated with it. So hence I'm saying it just depends on you and your career aspirations and basically the projections, the plan that you have for yourself. I, for instance, I'm independent. I've never joined or associated with a bar, and I can safely say for the past 6 years, almost 7 years, I've never been wanting for a job or like being without a job or a brief because of the networks that I made that didn't make it an essential thing for me to join a bar because I have more than enough work. In fact, I'm overloaded with the work that if I were to go to a bar, you know, it wouldn't make sense. I would be paying bar fees wherein I could be saving that money and doing something else with it. So it just depends on you.
Thank you. There's also a question, what is the most important skill you need to possess as a legal practitioner?
I think the most important skill I've learned is attention to detail. One needs to really pay attention to detail. And I think that, you know, the word lawyer or legal practitioner is a bit of a misnomer, considering what you actually really do. Yes, you're presenting the case, you understand the law, you have to interpret the law and play and fiddle with it, you know, perform some legal gymnastics with the law in order to get your client out of the jam they're in or present your case in a certain way to win the case. But one thing I've realized is that if you pay very close attention to the details and the facts within the case, and you are able to, with forensic precision, be able to slice through that thin line between fact and, if I may call it, superfluous information, and be able to then present your case solely based on those facts with you interpreting the law properly, and finding that golden, what do they call it? A golden thread in those facts that makes your case strong. And you can't do that if you don't pay attention to the smaller details. You know, case in point, there was a medical insurance, you know, like the likes of your Discovery, your Best Meds, and the likes, who were suing a client. Actually, it was the hospital who was suing the client because this medical insurance did not pay. And they sued the client, and had we not realized that, hey, hold on, actually, the day they issued the summons, the debt was 3 years and 2 days over. So that means this debt had prescribed, because prescription is 3 years, and they were 2 days over. And if you're not able to see those small intricacies, you know, you would have admitted to something that you didn't necessarily have to admit to. So that's why I'm saying, the more you pay attention to the smaller details, the better your case, the better legal footing you have towards the chances of winning your case. Thank you.
Thank you. Mo is asking, how do we join the mock courts for experiential learning? Are there law firms that are able to assist with experience while studying?
Good question, Mo. One thing that I particularly did when I was a law student here at Unisa is that I literally went physically to these law firms and said, hey, even if I'm just working 1 day a week just to gain experience, I'll do it for free. You know, instead of sitting at home and just doing my assignments on the computer, I'll just do this for free. And some of them are amenable to that. And one thing I've learned is that I also participated in the moot courts. That's why I'm mentioning it. In fact, I did the All Africa moot court representing Unisa twice. And one thing, the experience that moot court gives you is that it teaches you to research the law. Apart from presentation skills and everything, the biggest aspect that is underrated in this entire experience, it teaches you to research the law. If there's a case and you have to then distinguish between the admissibility of a case and the jurisdiction, whether a court has jurisdiction to hear the matter and whether it's admissible or not, being able to draw that distinction is very important. And the research that goes into making such distinctions is important. So these moot court experiences, they do play a role. They do assist in benefiting you and just giving you better skills one way or another. And so if you do them, hey, that's good on you, man. Well done. You should continue. And if you don't have an opportunity to do them, then I would say approach these law firms. You know, you just want to learn. So you're not in the business of making profit as yet. So even if you offer your services for 1 day a week, you know, free of charge, or you have that funding from SESETA, wherein the state is basically subsidizing you to learn, to do articles, just go on and do it. That's what I would have to say on that.
Thank you. We've got 2 last questions. Ray is saying that he's noticed that most firms of attorneys require both English and Afrikaans. Is this a new trend or has it always been there?
Ray, that is a trend that has unfortunately been there for the longest time. However, I must put a disclaimer that the official language of the courts is English, you know. So the Afrikaans aspect is most primarily to do with you being able to fit within the culture of that particular law firm, so that you find that that law firm that requires Afrikaans deals with maybe Afrikaans clients, or the personnel or staff that work there primarily communicate with each other in Afrikaans. But the language for court is English. All other languages are official, but you'd need an interpreter for all the other languages, so that everything that is translated to English. So it's not a new thing. It's always been there. I guess it just speaks to not what they expect you to know, but it's that they expect you to know Afrikaans. But I think it's about fitting into that culture of that particular law firm, wherein if they say, okay, my Afrikaans is terrible, but I think you know what I mean, that you are able to follow conversations if they are being held in Afrikaans in a boardroom, and you're not lost, you know. I'm sure if there's another law firm out there that is based, let's say, in Limpopo, in, let's say, Polokwane, or that would say, you know what, English and Sepedi, because let's say predominantly their clients are Pedi speaking people, and you know, in the culture, the organizational culture for that firm is that they just communicate in Sepedi. Then therefore it would then be able to put it on their advert that Sepedi would be an added advantage. So same goes for any other language. Thank you.
Thank you. Then there's also a question about whether to do a diploma in law or an LLB. So this person says that her niece has got a diploma, and the advice is that she gets an LLB. Is this good advice on my part?
I'm going to be a bit biased in this one, and I would say I would also advise you to do the LLB degree. And why I'm apart from being biased, because I've done an LLB and I can speak with authority to the opportunities that the LLB has offered me, and it has opened for me, is that there's a wider spectrum of things that you can do with an LLB as opposed to what you can do with a diploma. So the advice to do LLB is actually good advice that you received. Yes, so I would advise you to, if you have that opportunity to do the LLB, and it's within your plan, and you don't feel it's not something you're doing just for, let's say, money, but you actually do love doing the work as is, then by all means do it. Because at the end of the day, it's about what makes you happy. And if you are not happy even with the LLB degree, then stick to the diploma. Then that's fine. Thank you.
Thank you. The final question is now more to do if you want to be a judge or a magistrate. What are the steps?
Okay, so once you've done your LLB and you've been admitted, like all the judges and the magistrates, you know, they all have the degree that came before the LLB. They call it the B-Proc. But what you need to do is gain experience. So once in a while, or not once in a while, but every term of the court sitting, they then ask for people to come and act. So you act as a judge, you act as a magistrate. So I would, with my 6 years experience as an advocate, then say, oh no, I want to go act as a magistrate. So that means periodically I would then sit as a magistrate to gain that experience of being a magistrate, hear matters and adjudicate on those matters. And then once I've gained enough acting stints as a magistrate cumulatively, they make up maybe a year or two of experience of acting. Then I can say, no, then I would want to be a magistrate. And similarly with judges as well. But one should be careful against wanting to become a judge or a magistrate when the experience of actual practice is not enough. So I can't, for example, and not that I'm doubting myself, say I want to act as a judge right now with 6 years experience as practicing as an advocate, because I haven't had that wide spectrum of legal problems that has put me in a position to say, oh no, now I understand, corporate law, criminal law, mergers and acquisitions, conveyancing. I haven't had that wide spectrum. So the longer experience I have in practice, then the more experience I'm basically encompassing that would then help me to become a better judge. So hence you see that most of the judges are older people, like more, and I'm not being ageist, but people in their 50s who have accumulated this experience over years, who are then, when they're acting or they're actually presiding over the matter, you can see that they have the experience, they've dealt with such matters, and therefore they're just applying the law. So there are no special requirements to say you need to have a master's degree or a doctorate degree or be a professor or something to be a judge or a magistrate. It just requires that experience from practice. Then from other attorneys or advocates, then judges and magistrates are picked from the ranks. And there are a few courses that the magistrates and the judges go through as well to uplift themselves, like courses on writing judgments and the likes. So, but you would need that experience first. Just accumulate that experience before you can become a judge and a magistrate. Thank you so much.
Thank you so much. That brings us to the end of the questions. I'm just going to make a few announcements. We'll share some information and then we will end off the session. Thank you again, Advocate Nkabinde, for taking the time to be here with us this morning. I've certainly learned a lot about the legal profession, things that I was feeling uncertain about. So I really appreciate all the input that you gave and also your patience in terms of answering all the questions that came through from those who have attended. So just from our side, announcement that you need to register for the Virtual Grad Expo. Next live events for the Virtual Grad Expo will be on the 27th of July and the 17th of August. And the idea with the Virtual Grad Expo is that you can go and register now on the site, but on those particular days, you'll be able to interact with employers, professional organizations, as well as higher education institutions to plan your next step. So please make some time to go and register or to go and check out the site and then register so that you can be ready to participate in those live events. Then we also want to share with you that we'll be having another similar session tomorrow, but this one will focus on professional registration for educators with SACE. So the idea is that we would really want to invite education students to come and learn more about the professional route towards becoming a teacher and registering with the SA Council for Educators. More information about this event, as well as other events that we will be hosting in July and August, is available on the My Unisa events calendar. Then also attention to the Grad Next book that you can download for free. This book has got quite a lot of valuable information about, for example, preparing for interviews, how to look for jobs, starting a business. Advocate Nkabinde talked about the importance of networking, so there's also some tips in this book about networking. So please go to the website address that I've shared there on the screen and go and download the book. As I said, it is free of charge, and it will certainly help you to learn more about how you can prepare for future opportunities. And then lastly, from us, we would really love to hear from you. So if you have any feedback or suggestions or questions about these career events or just about your career in general, please send an email to Mrs. Mandu Makanya. Her email address is there on the screen. And then in terms of accessing our services from Counselling and Career Development, you are welcome to send us an email if you've got any questions or concerns that you would like to discuss. We also have online appointments that you can book with our counsellors. The link is also there on the screen. Or you can also contact a counsellor at one of our regional offices to make an appointment for in-person counselling. Our website at www.unisa.ac.za/counselling provides you with access to a lot of resources related to your career planning 24/7. And then on our YouTube channel at youtube.com/Unisa Careers, you are able to view a recording of this presentation, which will be posted by the latest on Thursday or Friday, and as well as any previous presentations that we've had. So please also hop onto our YouTube channel and go and subscribe to get notifications of new videos. So again, just from my side, Advocate Nkabinde, we really want to appreciate the time that you've spent with us. We certainly learned a lot from you, and we hope that we could invite you back at some stage for another session like this. Just as a comment, one of our participants, Mo, also shared, thank you so much. The workshop was definitely informative and eye-opening. Great work. Thank you. Mrs. Makanya, would you also like to just have a last word?
That's all, but just to say thank you so much to our own graduates and our own alumni for such a profound presentation. And thank you so much, Happy, for all that you have shared. And just want to say to students who are still hanging in there, is that to encourage you actually to say that push the best that you can to come to your career aspiration. And Advocate Nkabinde, we've known him since he was a junior student, and we've seen his diligence in hard work, getting involved in students' activities in the mock courts and volunteering in different activities of the university. So what he's been saying, we know, we've seen him, and it does pay off. And I just want to wish all our students everything of the best in their pursuit for their careers. Thank you.
Thank you very much, and we hope we see some of you tomorrow, or that you share the events about the education with some of your fellow students. Thank you very much.
Thank you. Thank you.